Hi everyone, welcome to this webinar on data subject access requests. My name is Lucy and I'm a solicitor.
And my name is Sana and I'm a trainee solicitor. We're both members of the data protection team here at Clark's Legal.
In this webinar, we will be discussing various aspects of data subject access requests, known more commonly as DSARs, or SARs for short. In recent months, we have witnessed a series of high-profile data breaches, including from the Electoral Commission, TikTok, and the Police Service of Northern Ireland. These breaches have been caused by external hacking and internal human error. These have brought data protection issues to the forefront of the public's mind, and with this comes an increase in DSARs received by companies. We are seeing these requests all the time, particularly in the workplace and in the form of freedom of information requests. And given the volume of data that employers process every day, DSARs prove to be intimidating and administratively burdensome tasks. In this webinar, we will be discussing some key aspects of DSARs. We will cover what are DSARs and who can make one, what's included in a typical DSAR, obligations when responding to a DSAR, what is personal data, exemptions for disclosure, risks for companies and penalties if policies are not properly followed, making complaints to the ICO, and a few practical considerations.
And remember, if you have any questions, just pop them into the chat box or email us.
So, starting with the basics. Sana, can you please tell us, what are DSARs?
So, a DSAR is a request made by or on behalf of an individual for information which they are entitled to ask for under Article 15 of the UK GDPR. There are no formal requirements or set format for how an individual chooses to make such a request, which means it can be made verbally or in writing. It can even be made through social media. The request does not actually have to include the phrase data subject access request. All it needs to do is make it clear that the individual is requesting access to their own personal data or requesting for it to be deleted or amended, for example.
The absence of formal requirements also means that a request can be made to any person in an organisation. It is therefore the organisation's responsibility to train its staff to recognise DSARs and to pass them on to the relevant personal department. If you have staff members who regularly interact with the public, we would suggest training them on this, so that you can minimise the risks of missing a DSAR and therefore missing the potential deadline to respond. If an organisation misses a deadline to respond to a DSAR, it therefore risks the matter being escalated to the Information Commissioner's Office, which can result in further action being taken, and in the most serious situations, a penalty being issued.
We've already sort of given this away by discussing what a DSAR is, but can you tell us, Lucy, who can make a DSAR?
So, any living individual can send a DSAR to an organisation for access to any and all personal data the organisation holds on the individual. It doesn't have to be the individual themselves who actually submits the DSAR. It can be done by someone on their behalf, such as their solicitor. If an individual instructs another person to make this request on their behalf, the individual must provide their consent to this by way of a letter of authority. When it comes to reasons for making a DSAR, there are many, and we will discuss some of these later in the webinar. What is important to know, though, is that under the UK GDPR, individuals have a right to access their personal data, and they do not have to disclose the reasons to the organisation for requesting this data.
Thanks, Lucy. Now we know that DSARs can take any form and they do not have to follow a specific format. However, it's clearly useful for all involved if DSARs do contain certain key bits of information. Lucy, I know that you often advise clients on making DSARs as well as responding to them. Do you have any tips for what a good DSAR should contain?
Yes. So, a good DSAR should be very clear about the kind of information the individual is requesting. It's important at the outset to consider exactly what it is they are looking for. For example, they might want performance documents or correspondence between colleagues about them. It is not usually helpful to just request everything, as the individual making the request will likely receive a huge amount of documents, which may be very burdensome to go through. The data controller is also likely to be less cooperative if the individual has made no attempts to streamline the request, and it's too excessive. A DSAR should therefore include a date range, and where appropriate, subject-specific parameters that the data controller can search within. If searching emails, it is useful to set out a list of people's names and the search terms the searches can be restricted to. It is also really important to include in the request all names and aliases the individual was known by. If, for example, they are known by just one initial, make sure that the data controller knows to search for that, or they can have a reasonable excuse for not making that search. It is also helpful to set out what systems the personal data is likely to be stored on if this is known by the individual, particularly if a high volume of data is being requested. Once the DSAR has been received, a data controller, meaning an organisation which holds such personal data, has certain obligations on how it responds to a DSAR. Can you tell us what some of those obligations are, Sana?
Yes. So when it comes to responding to a DSAR, an organisation must respond without undue delay, and in any case within 1 month of the request being made. For example, if an individual sent a DSAR to an organisation on the 25th of May, then a response would be due by the 25th of June. This is not a lot of time if there's a lot of data to search for and review. The deadline to respond can be extended to up to 3 months if it's not possible to abide by the 1-month deadline. However, this is only if the request received is a complex one or there are significant requests being made by the same individual. To extend the time period for responding, the organisation must contact the individual within 1 month of the DSAR being made in any case to inform them of the extension of the deadline and explain to them why it's necessary. As well as providing the individual's personal data to them, which we will talk about in a bit, the organisation should also explain to the individual who their information is disclosed to and why the organisation is holding it in the first place. Formulating the actual response to a DSAR is not as straightforward as one might think, because if you are giving an individual access to their personal data, you need to first know what personal data is. We all probably have our own views on what we consider to be personal, but legally speaking, there is a very important definition. Lucy?
Yes. Under the UK GDPR, personal data has a very wide definition. It is any information relating to a particular living person which can be used to identify the person, whether directly or indirectly. Let's go through a few examples. So, Sana, if an employee submits a DSAR and there is a document containing an employee number for this particular employee, but it does not contain the employee's name, would this document be disclosable?
Well, the answer depends on whether the employee is identifiable from this document. So if the employee number can be used to identify this employee, whether directly or indirectly, then yes, this data will be personal data and is therefore disclosable.
Thank you, Sana. Another example, and this one is a little less straightforward. If I've sent an email to Sana asking, what time did you get into work today? Regardless of whether or not Sana responds to my email contains her personal data. The reason is that it can be deduced from my email that Sana came to work today, which is a piece of personal information about her. And the fact that the email was sent to Sana's email address means she can be identified from it. An email such as this one would have to be disclosed if Sana were to submit a DSAR in this situation. An important consideration when responding to a DSAR is other people's or third-party personal data. If Sana did make a DSAR, she would only be entitled to her own personal data, not that of other people. That is, of course, unless those other people have consented to the disclosure of their data in this situation. So if we had to disclose this email to her, we would need to redact from it any data which Sana is not entitled to see. Since I'm the person who sent the email containing Sana's personal data, my email address would also be on the document, and my email address would need to be redacted. This is the case even if Sana obviously knows that it was me who sent this email to her.
This explanation that Lucy gave actually addresses the question of whether an organization has to disclose everything. And the answer is no. A data controller should only disclose the individual's personal data. So again, this is any information which can be used to identify the individual directly or indirectly, and the organization should not disclose other people's personal data. And going back to the example of the employee number in a document, if a document contains employee numbers for other employees who do not consent to their personal data being disclosed, then all of those employee numbers will have to be redacted. Only the number for the employee who made the DSAR is disclosable. It's important to recognize that this is a different test to disclosure, which can take place in the employment tribunal or civil courts, for example. In fact, if a document contains the personal data of two people, and it's not possible to disclose the personal data of the individual making the DSAR without also disclosing someone else's personal data, then the information or document should not be disclosed altogether. Third-party rights to privacy take priority in this situation.
There are also exemptions to an individual's right to view their personal data. Some of the most common ones are legal privilege, business or management forecasting, and criminal investigations.
So even if a document contains the individual's personal data, if the document is, for example, a solicitor providing the organization with legal advice on how to deal with this specific individual, then the exemption of legal professional privilege applies, so the document should not be disclosed, unless such privilege is waived. If we again consider the example of an employee number in a document, let's say this employee number was provided in the context of management making internal business decisions, such as a redundancy or restructuring exercise, and these decisions are confidential and have not taken place yet, then this does not have to be disclosed to the employee making the DSAR. A possibility is redacting everything in the document other than the employee's individual number, even if this does not provide any context for the individual. In terms of the criminal investigation exemption, this would apply for the prevention or detection of crime, the apprehension or prosecution of offenders, or the assessment or collection of a tax or duty are also included. If this is the case, the exemption applies only to the extent that complying with the DSAR is likely to prejudice the crime and taxation purposes. It's important to note that such exemptions should be considered on a case-by-case basis and should not be used as blanket exemptions to justify denying access to whole categories of personal data. There are other exemptions that can be applied, which we have listed on the slide, but unfortunately we do not have time to consider these in detail today.
Let's go through a few example scenarios now. Here, we have a WhatsApp conversation, which took place between two colleagues through their work phones. You can see that Steve says to Angelina, "I don't feel like working today." When Angelina asks why, Steve replies, "Because Mike called a meeting with me." So, Sana, I have a few questions for you. If Steve submits a data subject access request to his employer, is this part of the WhatsApp conversation going to be disclosable?
If Steve submits a DSAR, then firstly, yes, a section of this conversation will be disclosable, and that's the part where Steve says, "I don't feel like working today." That's because although this is work-related, it is talking about Steve's emotions, so that's his data and it's personal to him. Of course, we must remember that the data must identify Steve, and over here, it clearly does because he is the one saying this, and so his name is right there as the sender of that message. So yes, we would disclose this sentence saying, "I don't feel like working today." As for when Steve says, "Mike called a meeting with me," this part is not as straightforward. On the one hand, we don't know what that meeting is for. It could just be work-related, and with no indication as to otherwise, we will assume it is, so we wouldn't disclose it, as it's not personal data. On the other hand, the context is showing us that this is the reason Steve does not feel like working today, which does make it personal. So if this specific sentence was just said on its own without any context, I would say that's work and not personal data. But if we had a conversation in which, out of the blue, Steve suddenly said something like, "Mike called a meeting with me to talk about my behavior," then that would definitely be Steve's personal data. So even without any other context, it would be disclosable. In this scenario, though, it's due to the context that we would disclose Steve's reason for not feeling like working, but we would redact Mike's name, of course, as he is a third party. Here's an example of how this conversation would be disclosed in its redacted form, if you'd like to take a moment to look at that.
Okay, going back to the full conversation, my next question is, if Mike submits a DSAR, is this conversation disclosable?
We might be tempted to think that when Steve said Mike called a meeting, that's Mike's personal data. However, it's actually not, because again, this is in the context of work, and Mike doing his work, his job, is not personal to him. So no, if Mike submits a DSAR, this conversation is not disclosable, even though it mentions his name. Another point to consider is, even if the conversation actually did include Mike's personal data, we might not know for sure that this is the right Mike. There could be several Mikes working at this company, whom Steve could have been referring to. In a situation where we are unsure of which Mike the personal data relates to, this should not be disclosed.
One thing to keep in mind is an organisation can only be asked to disclose the data that's in its possession or control. An organisation cannot search for the personal data on its staff's personal devices. However, they do have an obligation to search on work devices, as that is within their control. That's why we mentioned this WhatsApp conversation in particular took place on the work phones of 2 staff members. This means that this conversation is the employer's property, and it can therefore be searched and potentially disclosed as part of the employer's DSAR response.
In this next scenario, we have a section of a conversation that took place on Microsoft Teams, which is a very popular chat platform in the working world. Conversations on Teams may very well contain personal data because they're a lot more informal and instant when compared with emails, for example. Here we can see a chat between 2 employees, Jess and Peter. Jess says, "Can you please send me your notes of last week's meeting?" Peter responds with, "Yeah, sure. What have you been up to, by the way?" Jess says, "Not much, just been working a lot with Rob Harvey. He's so annoying." Question for you, Lucy. If Jess submits a DSAR to her employer, is this Teams chat going to be disclosable?
Well, let's take this bit by bit. The first 2 texts, where Jess asks Peter to send her his notes, and he says, "Yeah, sure, what have you been up to?" do not contain any personal data. That's because the notes part is simply discussing a work area, and all Peter did was ask a question, which didn't have any personal assumptions to it. If Peter had said, "What have you been up to since your birthday party last week?" that would have been Jess's personal data. The next bit, where Jess speaks ill of Rob and says she's been working with him, none of that is Jess's personal data. Arguably, saying Rob is annoying is Jess expressing her opinion, however it's still not personal to her.
Well, I have another question for you now, Lucy. What if Rob submitted a DSAR? Would the part where he is being described as annoying have to be disclosed to him?
This may be surprising, but yes, it's potentially disclosable. Although this is Jess's opinion, and it's therefore not a fact about Rob. He could be a very nice person and not annoying at all. If it's clear which Rob this text was referring to, then yes, it is disclosable. Rob's surname being in that chat is a strong indicator that he is identifiable. According to the Information Commissioner's Office, opinions and inferences are also personal data if the individual can be identified from that data, either directly or indirectly, and the information relates to that individual. This is actually one of the most common reasons that employees submit DSARs, to see if there are any opinions being expressed about them by colleagues, which they can use to support claims or grievances.
So let's see how this conversation would be disclosed if Rob was to submit a DSAR. As you can see, everything has been redacted except Rob's personal data. Sadly for Rob, if he submits a DSAR, he will have access to this text where someone calls him annoying, but he won't be able to find out who that was. It's important to protect the personal data of others, particularly if they have not consented to such disclosure, and that includes their names, of course.
As we explained earlier, DSARs come in a variety of formats and are submitted for a variety of reasons. We come across them very frequently in the context of employment claims and grievances, and have a team on hand who can help clients to work through the data and determine what is disclosable. Often, DSARs we see are from employees who have been dismissed, who request their personal data from their dismissing employer in order to find out what that employer has within their possession, and to potentially try to use any such information in building a case against the employer for unfair dismissal. We also see them from employees who are pursuing a grievance against their employer, or someone in their organisation, to see if any information has been shared that can clarify or assist with their grievance. Many people are also wary of their personal records being on file in some organisations, so there are instances whereby an individual requests to find out exactly what personal data an organisation holds on them, as well as the organisation's reasons for holding this personal data. If the individual is not satisfied that there are legitimate reasons for holding the personal data, the individual may ask that this data be deleted from the organisation. It is also therefore important that organisations have clear retention policies and procedures in place in respect of personal data, which is also communicated to individuals.
As an organisation collecting and using information on individuals, you must be clear about why you are doing this. As part of the response to a DSAR, an organisation must provide the purpose and legal basis it has for processing personal data. For example, if an employee submits a DSAR to its employer, the employer would have to provide the employee with access to the employee's personal data, and it would also have to state the legal basis it has for having that employee's personal data to begin with. This could be the employer's legitimate interests in managing or terminating the employee's relationship with the employer, or establishing the employee's training requirements, administering their pay, gathering evidence for disciplinary action. There could be many legitimate reasons for having such data on an employee, such as also complying with a legal obligation and such processing being necessary to comply with the contract in which these would need to be stated. Let's now discuss the potential risks of not responding to a DSAR properly. Let's say an organisation missed a deadline or did not provide all of the personal data it should have provided to the individual. Or maybe the organisation provided data it shouldn't have. Or even yet, the organisation failed to respond completely. What are the potential repercussions of this?
Well, only last year, the Information Commissioner's Office, or the ICO, took action against 7 organisations who failed in their duty to respond to DSARs. These organisations had either failed to meet the deadline or failed to respond at all. The ICO issued each of these organisations with a reprimand. These reprimands are a formal expression of the ICO's disapproval. Reprimands are now published for public interest purposes, so it can potentially result in an organisation suffering public embarrassment and negative press. Sometimes a reprimand asks an organisation to report back to the ICO on steps it has taken to correct any non-compliance. More seriously, the ICO is also able to issue fines for data protection breaches, and this depends on the seriousness of the breach. The largest fine the ICO can issue is £17.5 million, or 4% of the organisation's annual global turnover, whichever is highest. When it comes to disclosing information as part of a DSAR that the organisation should not have disclosed, for example, third parties' personal data, this is a failure by the organisation to protect personal data and is also actionable. You may have seen in the news recently how serious it is for an organisation to fail to put appropriate measures in place to protect personal data, and how significant the fines for this can be, which can cause financial and reputational damage.
Yes, indeed. We are yet to see what the potential penalties will be for the Electoral Commission and the Police Service of Northern Ireland, who have both been in the news recently. But last year, the ICO fined the construction group Interserve £4.4 million after a cyber attack enabled hackers to steal the personal data of individuals. We unfortunately do not have time to discuss these cases in more detail, but these consequences are good to keep in mind when responding to a DSAR, because accidentally disclosing the personal data of others is also a failure to protect personal data and constitutes a data breach. It's a good idea for an organisation to have a policy in place for DSARs. For example, firstly, as we stated earlier, having its employees recognise a DSAR and pass it on to the relevant people. Secondly, the deadline for responding to the DSAR should be logged to make sure the request is actually dealt with on time. This step should include making sure the DSAR is valid by checking the identity of the person submitting the DSAR, or if the DSAR was submitted on behalf of someone else, then checking the letter of authority accordingly. As we mentioned earlier, it is common for a DSAR to specify details such as the names of people who have exchanged documents likely to contain the individual's personal data, and in an employment context, this is usually done by the individual requesting that a search of their name or their nickname is made against the mailboxes of certain employees working in their department at the company. And finally, as part of responding to a DSAR, an organization should have a system in place for reviewing the organization's documents to check for the individual in question's personal data. Oftentimes, the amount of documents which will need to be checked for the individual's personal data is massive. It's important that whoever is checking these documents for personal data is familiar with the meaning of personal data and careful about only disclosing what needs to be disclosed. It's also crucial to keep track of the deadlines in order to inform the individual if there will be a delay due to the complex nature of the request or the amount of documents which need to be reviewed, or both.
If an individual has faced problems accessing their personal data from an organisation, the individual can escalate the matter to the ICO. If an organisation fails to protect personal data, anyone, so not only the people whose personal data has been mishandled, can make a complaint to the ICO. But to make a complaint on behalf of someone else, that person must have signed a letter of consent to this first.
In making a complaint to the ICO, the individual will fill out a form on the ICO's website and will need to provide copies of any communications, such as letters or emails about the complaint, between the individual and the organisation, and any other evidence that supports the complaint. Prior to taking this step, however, the individual must have complained to the organisation first and should even follow up if the organisation did not respond, or if it responded with something the individual does not understand. If after following up the individual is still not satisfied with the organisation's response or lack of response, they may wish to consider escalating the matter to the ICO, but it must be done within 3 months of the individual's last communication with the organisation.
Moving on to discussing the practical considerations and realities when responding to DSARs. Although we have already touched on this, let's talk about why individuals make such requests in the first place.
There are many cases in which individuals genuinely want to know what data an organisation holds on them, and this may be simple curiosity or needing the information. For example, individuals may want to see their medical records in order to help them get a second opinion. We won't go into the psychology behind such personal decisions, and just as we said before, individuals are entitled to know what data an organisation holds on them, and they do not need to provide their reasons for wanting to know.
There are, however, other reasons which we believe are especially relevant in the employment law context, as that is where we are seeing many DSARs. If an employee is dismissed or has had some fallout with their employer, they might want to submit a DSAR to find out whether the employer followed a fair process in dismissing them, because the employer's internal processes likely involve discussing the individual's personal data, and this may therefore potentially be disclosed.
One issue individuals may not necessarily appreciate, however, is that the final product of what is disclosed may be so heavily redacted it's not possible for it to be of any use. As stated earlier, an employer does not and should not have to disclose information other than the individual's personal data, where this differs from the test of disclosure which is required in the employment tribunal or the courts.
Furthermore, what is capable of identifying an individual, whether directly or indirectly, is not always clear-cut. If someone named Rob submits a DSAR to his employer, but there are multiple people named Rob at the company, it is likely that a document containing Rob's name would not necessarily identify the Rob who made the DSAR, as it could instead be referring to a different Rob. This document, even if in reality does refer to the correct Rob, would not be disclosable due to it being difficult to identify the original Rob. In such a situation, an organisation has to balance other third-party interests against those of the individual.
Another reason an employee might have in submitting a DSAR is to use it as a tactical device to pressure their employer to enter into settlement discussions with them. It's no secret that responding to a DSAR is an intimidating and administratively burdensome task. Generally, individuals do not need to pay a fee for making a DSAR, so all of the costs fall on the organisation dealing with it. It's only in exceptional circumstances that an organisation can charge a reasonable fee for the administrative costs of complying with a request, but this is only if the request is manifestly unfounded or excessive. So that is how a DSAR is used in employment disputes, to pressure employers to offer settlement agreements, etc. And that brings our session to an end. I think it's safe to say that we covered lots of different aspects of DSARs.
To recap, we discussed what a DSAR is, who can make one, the obligations organisations have in responding to DSARs, including considerations of what personal data means, and we went through some example scenarios to better understand this. We discussed the time limits for response and the consequences of non-compliance. We also reviewed the importance of protecting other individuals' personal data and making sure that this is not disclosed to someone who is not entitled to see it. We discussed the complaint mechanism open to individuals and the action the ICO can take. And finally, we considered the practical considerations of DSARs, such as the reasons people may want to make these requests and where there is dispute between them and the organisation. That's all for today.
Thank you for watching this webinar. We hope you found it useful. And remember, if you have any questions about anything we have covered today, then please feel free to send them through the chat box or email us.
Thank you and goodbye.